Good afternoon, everybody, and I'm very pleased to see so many people here today with us. The ongoing persecution of whistleblowers and journalists and publishers covering the revelation is a very serious issue with a huge impact on human rights, and is calling the attention of many people around the world. Nevertheless, up to now, it didn't receive the necessary attention by the Human Rights Council. And this is the main reason why the International Association of Democratic Lawyers, together with the Republic of Ecuador, decided to convene this side event. For example, now the Council is discussing since a quite long time, the issue of right to privacy in the digital age. But during all the debates, there was no mention of Edward Snowden, the very one man who, at great personal risk, allowed us to know the size and scope of the US mass surveillance program. The result of the ongoing crackdown on whistleblowers and journalists is the remarkable rise of Western refugees and dissenters who had to fly their countries looking for protection elsewhere. We have then Julian Assange locked up in the Ecuadorian embassy in London, Edward Snowden in Moscow, Laura Poitras, who recently won the Oscar for his documentary Citizen 4 in Berlin, and in Berlin there's also Sarah Harrison, a WikiLeaks journalist, and many others. At stake in this persecution is not just the fate of some brave men and women who decided their primary loyalty was to their country and to public integrity instead of to their employers. As we will see, what is at stake is the freedom of expression and freedom of the press of millions of citizens around the globe. Whistleblowers play a fundamental role in promoting human rights and democracy and upholding the rule of law. They represent a crucial source of information on human rights violations, illegalities, and wrongdoing. Their disclosure provides a unique opportunity to strengthen legal and political accountability for abuses that otherwise would remain undetected due to the increasing use and abuse of secrecy to cover unlawful policies. The aggressive pursuit of leaks is seriously affecting the reporting on critical issues, creating a climate of fear for journalists and sources alike. Investigative reporters are intimidated and persecuted in different ways for exposing the scope of the government's secret activities. The cases of James Reason, Glenn Greenwald, David Miranda, Julian Assange, WikiLeaks are just some examples. The resulting chilling effect on the press coverage of issues of great public interest pose a serious threat to democracy itself. The criminal prosecution and the stigmatization of whistleblowers as traitors or spies, and those who report on their revelation as they are accomplished, represent a grave breach of international human rights law. Whistleblowing requires courage and determination. Their commitment to public integrity should be encouraged and praised rather than condemned. Before I give the floor to the distinguished speakers who are with us today, unluckily I have to announce that finally Glenn Greenwald had to cancel his participation at the very last moment. But anyway, we will invite him again here very soon to share with us his concern and personal experience. Julian Assange, who will intervene in a short while, is already following our meeting from the Ecuadorian embassy in London. I now give the floor immediately to our... Hi, Julian.
Hi.
Very good to see you.
Thanks. Thank you.
We come back to you in a moment. I now give the floor to our first speaker, which is Professor Zayas, the UN independent expert on the promotion of a democratic and equitable international order. Zayas, you have the floor.
Hablaré claro. Your Excellency, distinguished panelists, ladies and gentlemen, every functioning democracy depends on transparent and accountable governance. Undoubtedly, secrecy is an enemy of democracy, and when governments conceal important information from the public, when there is no consultation and no public participation in decision-making, the legitimacy of governmental actions is put into question. Over the past 10 years, revelations by whistleblowers have shaken the confidence of citizens and have uncovered a dangerous pattern of arbitrariness and impunity. Documents reveal a complex system of concealment and manipulation in which dozens of governments have participated. Documents manifest a widespread animus to place perceived governmental policies above international law and above human rights law. Law is being invoked selectively and applied à la carte. Some would call this situation a conspiracy against democracy. Governmental secrecy has concealed the commission of war crimes and crimes against humanity, renditions, disappearances, torture, illegal mass surveillance of citizens without judicial control or accountability, the breach of lawyer-client privilege, and gross denial of due process. Whistleblowers have also thrown light on secret ongoing negotiations of comprehensive trade and investment agreements that compromise the very concept of state sovereignty and circumvent the principle of non-intervention into the domestic affairs of states in contravention of the letter and spirit of the UN Charter and countless General Assembly resolutions, including, of course, Resolution 2625, the Friendly Relations Resolution. I am talking, of course, about the secrecy surrounding the elaboration, negotiation, and possible adoption of the TTIP, the TPP, the TISA, and other treaties. Disclosures by whistleblowers raise many issues concerning international humanitarian law, notably Geneva Convention 3 and 4 of 1949 and its 1977 additional protocols. They also raise issues concerning civil and political rights, including the right of self-determination of peoples, the right to life, the right not to be subjected to torture or cruel, inhuman, or degrading treatment, the right to security of person, the prohibition of arbitrary detention, the right to freedom of movement, the right to independent tribunals and due process of law, the right to privacy and family life, the freedom of conviction, opinion, and expression, the rights of the child, the right to participate in the conduct of public affairs, the right to non-discrimination, the right of minorities, the right to property, and the right to one's homeland, that is, the right not to be subjected to forced displacement. Disclosures by whistleblowers also raise issues concerning economic, social, and cultural rights, including the right to work, the right to health, the right to education, the right to housing, to a safe environment, the right to water. Disclosures by whistleblowers impact the work of the Human Rights Council, the UPR procedure, and the special procedures. All of us are concerned, including the special rapporteurs on extrajudicial executions, on torture, on terrorism, on freedom of opinion and expression, on freedom of peaceful assembly and association, on the independence of judges and lawyers, on human rights defenders, on international order. Also concerned are the working groups on disappearances, on arbitrary detention, on business and human rights. Other important mechanisms have been seized of these issues, including treaty bodies such as the Human Rights Committee, the Committee on Economic, Social, and Cultural Rights, the Committee on the Elimination of Racial Discrimination, and the Committee Against Torture. These committees have individual complaints procedures that can and should be engaged to test the legality of certain governmental measures, particularly those in connection with the so-called war against terrorism. My former boss in the United Nations, Jacob Muller, and myself, I used to be chief of petitions here at the Office of the High Commissioner for Human Rights. We published a book, United Nations Human Rights Committee Case Law, which deals with some of these cases, including the famous Zayas against Belgium case. These committees also have an interstate complaints procedures that, although promising, are yet to be tested. They also have a procedure of periodic examination of state reports, which conclude with concrete observations and recommendations. How have governments reacted to the revelations by the whistleblowers? It is worrisome and distressing that instead of opening thorough investigations into allegations of war crimes, extrajudicial executions, torture, renditions, indefinite detention, and corruption, and instead of prosecuting those responsible, and not merely the lowly soldiers or those who have simply carried out orders, but those who have given the orders, established the policies, or given green light to the use of torture methods. It is the whistleblowers who are being defamed, persecuted, mobbed, threatened, and prosecuted. The age-old practice of blaming the messenger is alive and well in the 21st century. This again raises another set of concerns, this time with respect to the rule of law, obligations of government vis-à-vis the populations living under their jurisdictions, the imperative to respect the right to dissent and the right to peaceful assembly, the role of the media as a watchdog over democracy, the duty of journalists not to be propagandists for governments, but to practice investigative journalism so as to ferret out abuse and corruption. I am particularly concerned by the realization that the right to privacy of billions of human beings has been violated and is being violated by an unprecedented campaign of digital and other surveillance without court order. I am shocked that notwithstanding revelations concerning this thoroughly illegal and unconstitutional practices, that the system has not been dismantled and that this kind of Orwellian surveillance continues. In my years as professor, I have had the opportunity to offer a master's course on literature and politics, in which I have drawn lessons from Machiavelli's The Prince, Thomas More's Utopia, Harriet Beecher Stowe's Uncle Tom's Cabin, and more recently, literature. Most, if not all of you, have read the World War I novel, All Quiet on the Western Front, which so well describes how the young German soldier Paul Bäumer, a victim of war propaganda, who initially thought he was doing the right thing, whose sense of good and bad was abused by government indoctrination, gradually becomes bitter and disenchanted by the lies, pretense, and injustices. His is a bitter invective against sentimental romantic ideals of warfare. The narrative by Erich Maria Remarque demonstrates the gradual realization by Paul Bäumer of the senselessness of blindly following orders. This is the beginning of a consciousness of right and wrong, and also a principal motivation of gradual independent thinking, attempts to change things from the inside. Realization, however, of the futility of such attempts at reform, ultimately triggering whistleblowing as a heart-rending call for help. The Oscar-winning documentary Citizen 4, shown here in the Geneva Human Rights Film Festival, demonstrates that civil society has heard this piercing call for help. But the vehement persecution of whistleblowers is not abating. There is a governmental narrative reminiscent of Nazi times, that soldiers have to obey orders, period, notwithstanding the Nuremberg Principles, the Statute of Rome, the International Covenant on Civil and Political Rights, and countless resolutions of the Human Rights Council and General Assembly. The narrative of patriotism continues to color the discussion, even in democratic societies. A great many persons, young and old, repeat the formula, my country, right or wrong, and accuse whistleblowers of being unpatriotic, or worse, of being spies and traitors. And they threaten them with social ostracism and criminal prosecution. But in human rights terms, is it not more appropriate to perceive whistleblowers as the real patriots. Those who want to be proud of their countries and to combat abuses, to make things right, to strive for justice. Indeed, patriotism is not warmongering, but actively waging peace. It is not expansionism or looking for what land to invade next. It does not strive to subjugate others or take advantage of them. It does not aim at land grab or resource grab or other forms of economic exploitation and financial neocolonialism. Only chauvinism takes pleasure in exploiting others and doing injustice to them. Patriotism is consciousness of the noblest potential of one's homeland and the will proactively to advance this potential. It means working for social justice and against privilege and corruption. The former United Nations Special Rapporteur on Freedom of Expression, Frank LaRue, said in 2014 that whistleblowers are not only relevant for the news they carry, but because they mobilize the people. He stressed that the right to truth is not only related to individual events, but is necessary for salvaging this fiber of society. He observed, quote, "The people always have a right to know what is being done in their name. This is why we call it democracy. Otherwise, it wouldn't be the government of the people by the people," unquote. In 2013, our former High Commissioner for Human Rights, Navi Pillay, issued a press release stating that, quote, "National legal systems must ensure that there are adequate avenues for individuals disclosing violations of human rights to express their concern without fear of reprisals." Referring to the revelations of Edward Snowden, she emphasized the need to protect persons disclosing information on matters that have implications for human rights, as well as the importance of ensuring respect for the right to privacy, unquote. Following Navi Pillay's lead, civil society has taken up the issue, and countless non-governmental organizations have organized and are continuing to organize petition campaigns to demand governmental transparency and accountability, and to condemn the prevailing impunity of government officials implicated in crimes revealed by the whistleblowers. We all know that secrecy encourages an atmosphere of impunity. Although there are legitimate national security reasons for secrecy, such reasons do not provide for blanket secrecy beyond democratic controls. And while there is a huge governmental effort to conceal information from the public, there is another just as huge governmental effort to find out what people are thinking and to intimidate civil society into self-censorship. Another book you all have read, George Orwell's prophetic 1984 dystopia. Orwell shows us how persons are reduced to robots through the denial of the right to identity and its corollary, the right to privacy. We meet Winston Smith, an employee of the Ministry of Truth of Oceania, the totalitarian superpower. Winston keeps a rebellious diary which he endeavors to write when he is not being watched by the ever-present television surveillance. He seeks the love of Julia, a machine operator in the fiction department. He meets O'Brien, a member of the Brotherhood, in whom he confides, not knowing that O'Brien is a member of the Thought Police. Winston is apprehended and sent to room 101, where a person is faced with his greatest fear, in Winston's case, rats. Winston is psychologically broken and goes back to being just a number. He learns to live with a party and to love Big Brother. Ladies and gentlemen, whistleblowers are there to rescue us from Big Brother. To what end we will hear more, to that end we will hear more from members of this panel. I would like to conclude by appealing to civil society to show solidarity with whistleblowers and to stand up to defend democracy. I appeal to the Human Rights Council to vindicate the right to identity, the right to privacy, the right to know, the right to human dignity, for indeed human dignity is not in consumer goods, but in intellectual freedom and social justice. The Council may also consider tasking its advisory committee with a study on concrete measures to protect whistleblowers who disclose information which is relevant for the promotion and protection of human rights. Finally, I endorse the proposal to establish a new rapporteurship on the right to privacy in the digital age. I thank you for your attention.
Thank you very much, Professor de Zayas, for underlying the value of whistleblowing in a democratic society, and to recall us what is patriotism. I now give the floor to our next speaker, which is Mrs. Eva Joly, member of the European Parliament and former French judge with a long experience in fighting corruption and other white-collar crimes. You have the floor, ma'am.
Thank you very much. At first, I don't know whether it works. I first like to say how happy I am to be here with you, to participate in this event for a better protection of whistleblowers. And I'm also very happy to see Baltasar Garzon again, with whom I have worked as a judge. We used to fight corruption together, and today we are fighting together for the rights of the whistleblowers, because it is the same fight. It is the fight for the rule of law and for the strengthening of democracy. The whistleblower reports in public interests act in good faith on the basis of reasonable evidence or suspicion in a disinterested way according to the criteria used by the European Court of Human Rights. Let me give you some examples of whistleblowers whose actions helped move the lines. All of them have acted out of conviction because they could not stand anymore the public interest to be denied, the basic rights of citizens violated. And they each had at their respective level an impact on the legal and political actions. But their action also had a direct impact on their lives. I give you these examples because I personally know some of them, but also because the disclosure they made are directly related to my work as an MEP. Obviously, all whistleblowers would deserve to be cited in my speech. Firstly, Herve Falciani. He revealed information on more than 130,000 accounts in Swiss banks belonging to suspect tax evaders. As a result, an inquiry has been opened against several alleged tax evasion offenders. Despite the assistance he provided to the French courts, he had to flee first Switzerland and then France, and to spend several months in prison. Secondly, Stéphanie Guibault. Stéphanie has suffered harassment. She was demoted and eventually dismissed by the Swiss bank UBS for refusing to destroy documents that could have demonstrated a tax avoidance schema. After 7 years of struggle, she just won a lawsuit for moral harassment against UBS. For these 7 years of hell for her, she obtained 30,000 euros in damages. That's the reality of whistleblowers. This is the reality we must change if we do not want a non-transparent and unfair society, a society in which those who could report allow the improvement of law and general awareness, the proper functioning of democracy prefer to remain silent because they have too much to lose. Antoine Deltour, finally, former auditor at PricewaterhouseCoopers, this young 28-year-old man is the alleged perpetrator of some of the leaks that led to the famous LuxLeaks. LuxLeaks, as you remember, is the publication by a consortium of investigative journalists of 340 tax rulings that Luxembourg had given to multinationals all over the world, mainly Americans, and that allowed them not to pay taxes or nearly nothing in taxes. And this in a period where austerity is there for citizens, ordinary citizens, especially in Spain, in Portugal, in Greece, that are suffering. And in this context, allowing multinationals not to pay taxes at all is really a criminal action. So his whistleblowing allowed us to take a new political action. The Greens in the Parliament managed to set up a special commission to investigate the extent of the tax rulings in Europe. This is in a very difficult condition because, as you all know, the European Commission is headed by the former Prime Minister of Luxembourg. So nothing of this would have been possible without the courage of Antoine Deltour. He has acted by conviction. He stood up for his ideas. He considered that the removal of funds that should have been assigned to the public interest should be denounced. He says he is one element of a broader movement. I do wish so for democracy. So, but when you see what happens to the whistleblowers, you see that they are the ones who are being charged. Antoine Deltour is charged in Luxembourg. He is facing 5 years of imprisonment, while those who evaded taxes, stealing other countries' tax revenues, there is no inquiry as to these actions. And I think that for the citizens, this is very difficult to understand, that the whistleblowers are the only one who faces prosecution, as the professor told us. And so, thanks to the action and courage of these 3 whistleblowers, tax exiles, the bank advising them, big business evading taxes through tax schemes, states practicing fiscal dumping, do not sleep peacefully. They know that courageous people can report acts considered contrary to the public interest. State may still have a monopoly on surveillance, but it's the citizens who have the scrutiny and the denunciation one. Without whistleblowers, many scandals would have never been made public. This is probably the reason why their protection is still very weak at the international level. Too often, their courageous act is followed by an obstacle course, a personal, professional, and social loss, not to mention the financial and psychological consequences. Too often, whistleblowers are not protected. When court rulings is finally made, it is far too late and unsatisfactory. Whistleblowers have had time to be marginalized, insecure, to lose their jobs, to have their lives turned upside down. The current state of legislation, even the most successful one, do not encourage witnesses of malpractice, crimes, violation of general interest, infringements to the very foundations of democracy, to denounce those facts. Julian Assange, Edward Snowden are the symbols of the struggle of men sacrificing their lives to inform, to denounce, to strengthen democracy. Those who see them as opponents of democracy are dangerous idiots. They are also the symbols of the terrible consequences this can have on a life to denounce what we think unfair, illegal, unethical. Exile in Russia for Edward Snowden. Years, 1,000 days in the embassy of Ecuador in London for Julian, without any court having ruled on his case. And I want to express my gratitude to the Ecuadorian state and its embassy in London that has harbored Julian Assange for these 1,000 days. I happen to know him from a work I did in Iceland, and I'm really shocked that a country like Sweden has let 1,000 days go on without acting, and also because there is no real check and balance in the Swedish legal system. It depended on one woman who decided in her head, on her own, that she didn't want to go to London to ask him questions. She wrote on her internet page that she was not allowed to do so, which it's absolutely wrong. As former prosecutors and judges, we knew that this is really misinterpretation of international conventions, and that moving to another country, asking questions, is totally ordinary business. So I think Sweden has an answer to give. Why did they let this situation take 1,000 days? So we see the price that whistleblowers are paying, and unfortunately also what happened in the US, where the documents given out by Edward Snowden showed the whole world that billions of people are being spied upon. Nothing happened with this system. It is all concentrated on Edward Snowden, that in the wish of the American authorities want to prosecute him for publishing documents that were secret, even if they were of total public interest. And today in France, the socialist government has proposed a law that is a kind of copy of this law. They want also to allow the secret services to be able to act without any mandate, to get into people's houses, to make sound records, and all kind of very intrusive mechanism. And what is extraordinary to me is that in the polls, people like the idea, because they are being told that by giving up their freedom, I have nothing to hide, they say, they will have more security. And we know, as Roosevelt said, that by giving up your freedom, you don't get neither security, neither freedom. So I think we have altogether an important work to do. It is to understand the fundamental role played by the whistleblowers, and it is for us to ensure an international protection of them, because what we see is that we cannot trust the states to do so. So the UN should set up a new institution that could take care of the whistleblowers and or what they are saying, to act upon it. And I think that we should have a foundation that could also compensate in a way the lack of revenue that is the situation of the whistleblower. So this is in front of us, and we should not separate before we have some very concrete ideas how to move this situation forward. Thank you.
Merci beaucoup. Thank you very much for your intervention and for underlying the contribution of whistleblowers to justice and the price they have to pay for that. And to recall as well the unfair situation which is imposed to Julian Assange and other whistleblowers, and what can be done to solve this situation. I now give the floor to Judge Baltasar Garzon, which is a very well-known Spanish jurist and is actually head of the legal team defending WikiLeaks Julian Assange. Tiene usted la palabra.
Muchísimas gracias. Buenas tardes.
Thank you very much. Thank you, Madam Ambassador, and to all the other speakers. I would also like to greet my Sahrawi friends who are here in the room. As you know, Julian Assange is a journalist and an editor of WikiLeaks. WikiLeaks has published, and in this way shown, without manipulating any of the information, that many human rights violations have been committed in many parts of many countries of the world, committed by government authorities as well as non-governmental. The access to information is a sine qua non condition to be able to fully exercise one's freedom of expression as well as other rights. The Human Rights Council of the United Nations has on many occasions said that freedom of expression and freedom of information are of great importance for any democratic society. These rights, however, are the subject of a great deal of tension between states and the citizens. There is a clear trend by some governments to limit them due to different mechanisms. And of course, the most used is the war on terrorism. On this pretext, they justify the supposed protection of national security and systematic interference with the rights and freedoms of citizens. Julian Assange and WikiLeaks are being dealt with as such a threat by Western countries, when quite clearly that is not the case. So this is not a threat. This is a journalist and a means of communication that have the right to receive and communicate information as is. What they're attempting to censure is the ability in and of itself of giving and receiving this information. Before, it was done by prior censorship, and now with the threat and the prosecution of those who have access to that information. So the issue is, what value do you set by the reserve of information, national security, classified information, when it's used against citizens. What justification are all of these limits to the freedom of circulation of information? A law of secret acts can make legal activities illegal, and it will always do that. For example, an assassination, an invasion in somebody's private life, corruption, the invasion of a country. And the question is, why is it that those who have access to that information, which is illegal, are the ones that have to pay the consequences of disseminating the information? This is a very clear contradiction when, in addition, the dissemination of that information contributes to protecting citizens. So this type of persecution is unacceptable, and it cannot be justified legally. So there is certainly a point of importance to take into account, the 11th of September, and therefore interventionism became more important than privacy and protection of communication, seeking to intervene in a preventive way. And so the right of access to information needs to be harmonized with the right to the truth, the right to receive and communicate information. This is an essential element of the right to the freedom of expression. The right to the truth and to access to information are clearly interrelated. Any information in the hands of the state, of any state, belongs to the public, belongs to its citizens, men and women, with slight subtleties which need to be fully justified by the state authorities. Any limitation from a state, placed by a state, on the freedom of expression cannot endanger the right itself, and even less so when that information is related to human rights being denied. Not to facilitate information to a victim could lead to a liability by whoever is denying it. The Wall Street Journal informed on a very sophisticated type of air control over mobile communications in the US, which was being done by the US Marshals with authorization from the Department of Justice in order to ensure the content of and to listen in to conversations near the airports. This example leads to a confrontation between national security and the right to privacy, as well as the protection from outside interference in the network. The International Covenant technological advance and globalization engender new threats which threaten the right to privacy. And therefore, we need to guarantee habeas data and the correct access and use of information. Respecting human rights is not only a task for governments, but companies, corporations also have a duty, a significant duty, with regard to protecting the human rights of their own clients. And this is particularly important with regard to the intelligence and security services of the state. Other programs show how some states accumulate information on civilians, or the National Security Agency of the US in 2013 Edward Snowden revealed some information on this, and as you know, he is exiled in Russia. The international consequences of this information has been extraordinary. There has been diplomatic statements by many states, and this has started a debate, which also brings us together today, on the right to the privacy of persons around the world. In October of 2013, when the NSA, when it was informed that 23 world leaders had been spied on, increased international outcries against the massive electronic tapping carried out by this agency, on the basis of the principle that any measure which is an intervention or an intrusion on privacy needs to be on the basis of a legitimate objective and based on reasons that are to be governed by the judiciary and with transparent and independent parliamentary scrutiny. In other words, exactly the contrary of what has been done so far. The problem and the concern is even greater with regard to personal freedoms. Technology used in fighting terrorism, such as the drones, leads to very great concerns and problems. The defenders of individual rights feel that this can become a means of watching citizens without any type of legal writ to spy. And in many countries, this has turned out to be already a reality and not just a potential threat, because these measures have been taken away from the judiciary's terms of reference. In a globalized world, there are unwritten rules about universal communication. Some states, as I say, via their intelligence services, invade spaces that clearly violate fundamental rights. And the problem is even worse when the protection of national security, working against the fundamental rights of a democratic society, go beyond the borders of the state itself. In view of these coalitions and pressures by the states, curiously enough, those that have already signed international agreements to protect human rights. And we find ourselves in situations where sovereignty is broken down instead of a joint sovereignty of protection. And therefore, international engagements must be broken or simply succumb to more powerful states. The case of the Bolivian president, Evo Morales, when Edward Snowden was thought, according to the intelligence services, was being flown on the president's plane, shows the problems in this area when the presidential plane was forced to land in order to prove what the president himself had already said, that there was nothing. And this show of strength by large powers against smaller ones has led us to this. Eva Joly has mentioned cases of whistleblowers, and I would ratify what she has said as well as what Professor Zayas has said. I would just add that the Inter-American Human Rights Commission doctrine in this is quite clear. They say that those who protest at these irregularities are those who, by providing and publicizing confidential information, should be protected against any legal, administrative, or labor sanctions as long as they have acted in good faith. In other words, the will to protect this type of claimant would make it normal to investigate the facts that they are denouncing. The special rapporteurs for the freedom of expression of the United Nations and of the OAS, in a joint statement in 2013, have stated quite clearly that under no circumstances newspapers working with means of communication or members of civil society who disseminate reserved or confidential information on this type of program, since they are of public interest, could be subject to sanctions and penalty. In other words, international legislation, international organizations are all attempting greater protection, quite the contrary of what countries are doing in terms of systematically criminalizing the whistleblowers. The case of Chelsea Manning is one more example of what can happen. And later, we will be able to go into this at greater length. A person who has provided information which a lot of us thought was the case, but after publishing the WikiLeaks documents, among them the video on collateral murder, where you can see and there is proof of an air attack by the US that led to the death of 2 workers of Reuters in Iraq. This video took apart the Pentagon's official account of what had happened. How is it possible that the person to be persecuted for this are the journalists or those who are assisting the whole of mankind in revealing this information? Julian Assange has been now for more than 1,000 days, since the 19th of June of 2012, in the Ecuadorian embassy in London. Ecuador provided political asylum under the 1954 and 1951 conventions. Julian Assange has this right granted to him because he is being persecuted, in this case by the United States, for having published, edited, and facilitated knowledge around the world of all of this type of facts with regard to crimes committed by those whose obligation it was to prevent this type of crime. But in the case of WikiLeaks, it is not only the fact that it has been involved in this type of activity, which in fact is a confrontation with the intelligence services vis-à-vis the human rights involved. The prosecutor of the Manning case also warned the other newspapers that had published the WikiLeaks documents, but the Department of Justice also has taken very seriously the statements from the Manning case. In May of last year, 2014, Associated Press stated that the Department of Justice had had access to the register of at least 20 telephone lines between April and May 2012 in order to find out which source had filtered the anti-terrorist activities of the Pentagon in Yemen. A week later, it was discovered that the Department of Justice and the FBI in 2010 had had access to James Rosen's email, the chief correspondent of Fox News in Washington. But these facts continue. In the last few days, Chris Coleman, which referred to Morocco and to documents referring to Western Sahara. This is a new case which could become a second WikiLeaks. All of this shows that we are facing a devalued national security concept, which does not correspond with the national interest or the general interest, but in fact is to the benefit of those who run the policy. Google, we have just heard, complied with the investigation that is leading the WikiLeaks and Julian Assange case. 2.5 years after this, we have discovered or heard that thousands of emails have been handed over, and they refer to persons, both individuals and companies, who have nothing to do with WikiLeaks and the investigation that is underway. So this is once again a new example of an invasion of privacy and violation of human rights. This clear abuse of power, together with the conspiracy theory, leads us to discuss how we must protect ourselves against this trend. All we can do is come into those spaces where we can work. One of them is this, that of the United Nations, the Human Rights Council, the different committees that protect those human rights. In our case, by denouncing the systematic lack of recognition of the rights of a person who has spent almost 5 years subject to an investigation, a legal investigation, without ever having had access to the material that is part of the case, and he has not been able to put forward his opinion because it was said that legally it would not be possible. And here I'm signing both as a lawyer for Julian Assange, as a judge and a lawyer, that is false. The easiest thing in the world is to organize a rogatory commission. To request a statement is also easy. But what do we have now? 4.5 years later, having had no access and having not had the right to defend himself, without the slightest compliance with the possibility of contradicting those who are proceeding with him, how do things stand? We have been insistently saying that any legal action by Sweden and from the prosecutor's office is not going to remedy the fact that those guarantees were systematically denied. And we have been requiring them from the very outset of this case. At any rate, Julian Assange, and we will be listening to him in a moment, he has always been ready to declare, and as long as his fundamental rights were defended, protected. And that is why he finds himself in the situation that he is in. As a journalist, as an informer, as an editor of communication media such as WikiLeaks, and for having made known to the world at large the cases of corruption, abuse of power, and the illicit use of structures which, rather than protecting citizens, have been aggressing them constantly. Thank you.
Muchísimas gracias, juez Garzón.
Thank you, Judge Garzon, and for also reminding us the serious violations in the war against terrorism, and also about the drones and the surveillance programs, and referring to someone that has always defended national security. From someone that's always defended national freedoms, it is essential.
I'm going to give the floor to our next speaker, which is Mr. Julian Assange, who will intervene via video link from the Ecuadorian Embassy in London, where, as the other speaker remember us, is besieged since more than 1,000 days now. Julian, we are very glad to have you here with us, and you have the floor.
Thank you. It's interesting to be in Geneva again, although in an unusual virtual manner. 4.5 years ago, I spoke in this building about what we had discovered in the Iraq War, the US records of the individual deaths of more than 100,000 people, including more than 60,000 clear civilians, men, and women and children. At that time, the US Embassy in Switzerland stepped forward, and the US ambassador stepped forward to say that Switzerland should not offer me asylum, that it should not entertain giving me asylum. That was wrong. And subsequently, of course, Ecuador has given me asylum in this embassy, and it hopes, of course, its country as well, which is the only reason why I'm able to speak to you today. Switzerland, for its behalf, has recently done something quite important, which is it has given asylum to Husseinov, an activist in Baku, in Azerbaijan, who has now been trapped in the Swiss embassy in Azerbaijan for more than 6 months. I like to think of this as an interesting mirror case. In fact, the parts of the United States government came out to support that decision, whereas the Swedish government has been completely silent on the matter, and the State Department proper has been completely silent on the matter. So I want to look at how these particular cases are indicative of a broader phenomenon that's been happening in the West very clearly in the last 8 years. But I think the tendencies arise from the fall of the Soviet Union, and that the competition for moral space that existed with the Soviet Union has collapsed. And as a result, we see the tendencies that are inherent in powerful states, principally the United States and its allies, which are always there, but are kept in check only through scrutiny and criticism by other actors imbued with power. Now, the United Nations and the Human Rights Council has a role to play, in perhaps the most important role to play, to fill that vacuum of critique that existed in the Cold War, and to a degree kept the West honest and kept it from a collapse of the standards that it said it held dear, but which we might say were most important to it in order to criticize the Soviet Union in that competition for moral virtue as a state. Okay. First, let's review what has happened. The Obama administration, supported by varying degrees by its Western allies, in the last 8 years has prosecuted and investigated more publishers and journalists under the Espionage Act than all previous presidencies combined. In fact, more than twice as many as all the previous presidencies in the United States. That must be seen as not simply a gradual perversion of basic notions of freedom of the press and the rights of human rights defenders in the United States and the West, but rather something that approaches a collapse. I used to say that the West was different to the East and much of the rest of the world in that its methods of societal control were more sophisticated. That in the East, journalists are taken from their homes in the middle of the night, that in the West, homes are taken from journalists in the middle of the day. That the primary mechanism of censorship and control of the press and publishers and dissidents was economic. Through a variety of forms of fiscalization, economic pressure is able to be applied to human rights organizations, to newspapers, to individual journalists, to the publishers of books, that dissuades them from engaging in criticism of policies of war or other parts of what is commonly referred to as the deep state. That, I think, was true for many years, with occasional exceptions. What is novel about our present period is that subtle form of very effective thought control and censorship has now become so extreme that it is no longer subtle. It's become so extreme that it mirrors the traditional notions of censorship and human rights abuse that the West has always complained about when it wants to criticize the actions of other states. So let's look at it in a concrete manner. Today is the 1,566th day of my detention here in the United Kingdom without charge in any country, at any time. The 1,006th day of my detention in this embassy without charge, surrounded by police and UK intelligence activities, which the UK government has admitted. The police component alone now reaches £10 million, $15 million, approximately £15,000, approximately $15,000 per day spent on surrounding this embassy and trying to observe my visitors and myself. But it's not just me. 1,858 days ago, the United States government started what it called a whole of government investigation into WikiLeaks, the publisher, and its staff, me and our alleged sources. That investigation continues on and has expanded in a number of ways. The departments involved include over a dozen different US agencies publicly declared. The Department of Justice National Security Division, the Department of Justice Criminal Division, the Department of Defense Intelligence Agency, the DIA, the Pentagon, the US Army Counterintelligence Center, the State Department, the White House, the FBI as what has now become the lead on-the-ground investigator in the case. As recently as March the 4th, the United States government admitted that attempt to prosecute WikiLeaks and its staff continues. It admitted it in federal court in Washington, DC, stating that it is a investigation is led by the Department of Justice, National Security Division, and Criminal Division. In that case, we were demanding information about the illegal acts in this investigation. WikiLeaks has filed a number of criminal cases in Denmark, in Sweden, in Germany, in Iceland, in relation to the criminal conduct of US intelligence agencies supported by SAPO in Sweden and PET in Denmark. Into trying to understand the abuses in this investigation, we asked the US federal court system for further information. Now, the US government has resisted that case for years, claiming that to reveal any details at all about lawyers being spied on, about our supporters being spied on, about supportive journalists being spied on, about other aspects of its investigation against us and its attempts to prosecute WikiLeaks and its staff, would compromise that investigation and that attempt to prosecute us, and therefore not a single document can be released. Now, of course, it is an absurdity that every single person who's been swept up that investigation still remains a suspect. It is an absurdity that every piece of evidence or witness statements having been obtained still would materially affect the attempts to prosecute me and other aspects of the organization. And in its judgment, that court gave a reason for its agreement with the US government. And the statement by the court illustrates that while the excesses of the US government in its executive are clear, it is not an excess that can be healed by appeal to the judicial system in those states. And I think that is something that is very important to realize. We often talk about excuses often made for abuses in the West, that an abuse by the executive can be healed or is healed in a short amount of time by appeal to the judiciary and the judicial branch or to the political branch of these states. But when an investigation, an attempt to prosecute and extradite and spy on a publisher goes now for more than 1,858 days, and the editor, myself, of that publisher is detained without charge for 1,566 days, and attempts to find means of opening up that investigation to show its illegality are denied by the courts, we can no longer say that the West can heal itself. It requires other bodies, such as the UN Human Rights Council, to step forward and fill the vacuum that has occurred. In that case, the judge stated that on March the 4th, it was necessary to show, quote, appropriate deference to the executive in matters of national security, unquote. And that is why the judiciary refused to examine any of the documents in the case as to whether they really would affect the course of that investigation, or the matters that revealed abuses in that investigation should be disclosed to the public. So this is an extraordinary statement. The necessity of the judiciary to show appropriate deference to the executive. That shows that there is no longer a separation between the judicial branch of the United States and the executive, when statements like that are coming from the mouths of judges. And it is not something that has arisen just for our case on the 4th of March. Actually, that notion that the judicial branch must give way to the executive whenever the executive claims something is a matter of national security is a development that has been evolving over the last 5 or so years. Okay, other people affected by this phenomenon are Chelsea Manning, an alleged source of WikiLeaks, alleged to have disclosed information, including diplomatic cables and the video that Baltasar Garzon mentioned, showing the slaughter of Reuters journalists in Baghdad and more than a dozen Iraqis at the same incident. He has now been detained for 1,760 days. His appeal is occurring later this year before the US Army Court of Appeal, but he has been sentenced to 35 years on an allegation, and it is the only allegation, that he disclosed information to the press. There is no allegation that he disclosed information to foreign states or to terrorist organizations, or that he acted for personal gain, purely that he disclosed information to WikiLeaks and the rest of the press. Special Rapporteur for Torture, Juan Mendez, in that case, formally found against the United States, and that Private Manning had been subjected to unlawful, cruel, and unusual punishment. In order, his lawyer says, to get him to make a confession in order to pursue the prosecution against me. Jeremy Hammond, sentenced to 10 years, now on his 1,112th day of incarceration in the United States. The allegation against him that he disclosed information about a private intelligence contractor, Stratfor, in the United States, to us. And we revealed that that contractor, Stratfor, had been involved in spying on activists involved in the Bhopal disaster in India, and had been engaged in an activity to create an unlawful captured investment fund, bribing people around the world to obtain information, yes, to sell to the US government, but also to inject into their own private commodities fund. Barrett Brown, US journalist, now detained for 921 days, recently sentenced to 6 years in prison. One of the allegations against him, which he was convicted for, was the extraordinary claim that by tweeting a statement made by Fox News against me, that he was threatening the FBI. Barrett Brown was drawing attention to a statement by Fox News asking for my assassination, calling for my assassination. By tweeting that, the FBI said that this was an attempt at assassination against him. I had hoped to go through the rest, but it seems that actually there are so many, it takes quite a long time to get through. But let me just give the names. These are not old cases. These are cases that have been ongoing where the person has been sentenced in the last year or are still proceeding. James Risen was mentioned earlier, New York Times journalist, threatened for years with imprisonment. His alleged source, CIA source, Jeffrey Sterling, is up for 100 years in prison. He's been sentenced on April the 24th. He was convicted on January 26th. Only allegation against him is that he supplied a New York Times reporter with information about the CIA. John Kiriakou, the only person arrested and convicted in relation to CIA torture, the only person in the United States. His role, revealing the torture. Sentenced to 30 months in prison after a case that dragged on for years. Thomas Drake, eventually sentenced to 1 year probation, but forced for 7 years to believe that he was going to be facing decades of incarceration, revealing, it is alleged, information about the National Security Agency, and earlier Edward Snowden. William Binney, similarly in relation to National Security Agency. Aaron Schwartz, in the United States, faced 50 years of imprisonment and $1 million of fine. A personal friend of mine, a volunteer for WikiLeaks, who ended up very sadly being persecuted literally to death 2 years ago. Glenn Greenwald, known to many of you here as one of the Snowden journalists, now in effective exile in Brazil. Laura Poitras, another Snowden journalist, now in effective exile in Berlin. Our Sarah Harrison, who assisted us with transporting Edward Snowden from Hong Kong into a place of asylum eventually in Russia, which we arranged through legal and diplomatic means. A case where a number of other countries represented here at the UN Human Rights Council also tried to assist, but the intervention of the United States was so aggressive and so abusive that came not to be. And those states include Ecuador, Venezuela, Bolivia, Nicaragua, and political support from Argentina. I think it is important to recognize that these states in this situation, with the United States threatening people as they attempted to give Edward Snowden assistance, stood up and tried to do that. In the end, the abuses of the United States in taking down President Emo Morales' jet, for example, were so extreme that he could not practically be safely conducted from the airport in Russia to Latin America. And there are many other current examples, although I think it's perhaps wise to give you one related to this body, the United Nations. We revealed information about Secretary Clinton's orders that the United Nations be spied upon, that the Palestinian community be spied upon, that particular NGOs be spied upon, that their DNA be stolen, that their fingerprints be stolen, that their retinal scans be stolen, that their passwords be stolen. But there is another case here in the United Kingdom of something similar. Catherine Gunn, now in effective exile in Turkey, a GCHQ translator, working at the GCHQ at the time when the United States was attempting to embroil the Security Council in authorizing its unlawful war against Iraq. She received, and the GCHQ received, instructions from the United States to spy on all the members, especially the non-permanent members of the Security Council, in an aggressive manner in order to influence them and produce a resolution for the Iraq war. Okay. What a number of these cases have in common is not simply that they are recent or that they are conducted sometimes without any charge, or that there are abuses in the formal process. It is that a technique has been developed in the West of punishment as process. So look at the case of Drake, the NSA whistleblower who went through a 7-year process to be sentenced to 1 year probation on a small charge. So here is a case where the process was clearly the punishment, where the abuse and the general deterrent is pushed into the case before eventual conclusion in a Supreme Court or in a higher court, before a trial. In my case, that's thousands of days now of detention without charge at all, not even having the rights of a defendant in the matter in the United States, not having access to any single document about the investigation of our organization. I think that there needs to be some clear policy designed to prevent this punishment as process that is occurring here. In the countries of the West, through their bureaucratic sophistication, have, in response to extremely good standards set up by the Council of Europe and the UN human rights system, adjusted their legal and administrative processes in order to engage in forms of abuse and to set general deterrents that evade the formalized checks and balances that the United Nations and others have tried to construct over a long period of time. I think this is something that is an increasing tendency, and I'm not sure the exact mechanism that is needed to address it. But when when claims of state secrets are used to knock out nearly all of the CIA torture cases that were brought in the United States, and used in the manner that I described in relation to us to prevent proper accountability in the US case, are used by Sweden to construct complete impunity into the renditions with the CIA by Swedish intelligence services against asylees in that country. This is a phenomenon that the rest of the world must step in to stop. Okay, so with that, I want to finish on one last point. If we try and pull back from these individual cases and abuses that I have mentioned, to look at this from a geopolitical perspective, what is happening is not simply an increasing tendency towards authoritarianism in the West. There is a desire and a method being erected for the United States, principally, to engage in an extraterritorial land grab through the abuse of law, where it is attempting to apply its jurisdiction to all countries in the world, to reach into other countries and destroy their sovereignty by demanding that its laws apply to their territory. Now, if you control the laws of a foreign country, if you say that your laws apply to the interior of a foreign country, this is the same as having effective control over the population of a foreign country, which is the same as, in a way, annexing that foreign country. Now, the United States has been doing this in a unilateral manner, where it claims universal jurisdiction in relation to everything that it says has to do with national security, including publishing. Similarly, it has also been involved in entering into often coerced bilateral and multilateral agreements on extradition and the sorts of activities that might be forced to be illegal, for example, in the Trans-Pacific Partnership Agreement. In Alexandria, Virginia, in Washington, D.C., where the grand jury for WikiLeaks is seated, more than 67 other countries are also embroiled in having their nationals being pulled in to that jurisdiction in one way or another. Whether that is, for example, here in the United Kingdom, a man who sold batteries to another state, which was then shipped to Iran, and the United States eventually extraditing that businessman to the United States for what it says was a breach of sanctions in relation to Iran, or whether it is in its media cases, where it has claimed that WikiLeaks, a publisher which is not based in the United States, which is headed by an Australian, myself, which is has its principal staff in Europe, that publisher and all its staff are susceptible to its claims of, and they came out earlier this year, espionage, conspiracy to commit espionage, the Computer Fraud and Abuse Act, which is computer hacking, theft of government secrets, and general conspiracy. This means because of how media organizations work, that once an allegation is taken against a single journalist for being involved in publishing information about the United States national security, including the CIA, its torture programs, or any other matter that the United States claims has something to do with its national security, that all other persons within that media organizations can be embroiled, all of them, the publishers, the editors, the journalists, because that's how information flows through a media organization. It goes from journalist to journalist, from editor to editor, to the technical people who prepare publications. And that is how it has managed to construct a case against a foreign media organization, how it has embroiled Google and other organizations to provide it with information, is by saying that this conspiracy somehow encapsulates all journalists in a foreign media organization. And that is something which is right now chilling the behavior of journalists across the world. I have seen it. I have spoken to other journalists here in the United Kingdom and other parts of Europe, or in New Zealand and in Australia, who will not publish certain information about the United States because they believe the United States will claim that they are susceptible to its laws. And that is an annexation of the democratic sovereign rights of other countries by the United States through its claim of universal jurisdiction whenever it says that its national security sector is involved.
Thank you very much, Julian, for your intervention, and we are looking forward to see you here in the Human Rights Council in flesh and blood as soon as possible, to continue with your brave struggle for the promotion and protection of human rights. In the meantime, as the International Association of Democratic Lawyers, we are going to follow and to work on your case, of course, and the other cases of whistleblowers and publishers you just mentioned, because we totally share your concern. Before I give the floor to our next and last speaker, Her Excellency Maria Fernanda Espinosa, Ambassador and Permanent Representative of the Republic of Ecuador at the UN in Geneva, I want to deeply thank Ecuador, not only for the precious help in co-organizing this side event, but also for everything they are doing to defend and promote free press around the world. Ambassador, you have the floor.
Thank you very much, Madam Moderator. Nicole has introduced us all, but no one has introduced Nicole. Nicole is the co-organizer together with Ecuador of this side event, and she represents, sorry, I'm switching into Spanish. Ella pertenece a la asociación.
And she belongs to the International Association of Democratic Lawyers, which is a network that has supported this cause. I would like to particularly greet the colleagues at the panel, ambassadors who are here present, the delegates from the accredited missions in Geneva, and those colleagues representing civil society who are also here with us this afternoon. Thank you very much for being here, for such a great turnout. Espionage and the control of information for manipulation to the benefit of geopolitical interest is a serious threat to peace, security, and represents a major attack against human rights. This is why we are holding this conversation here in the heart of the Human Rights Council. Let us stop for a minute to think about what is really going on right now in the world. Before I walked into this room, I made a phone call to Ecuador that was recorded just as all of my communications are. I sent a text message which was saved to be used against me or against anyone else if that is so desired. All of our emails are archived, read, and analyzed by special computer programs, special software, and by human beings when that is considered to be necessary. Our personal lives stop being our private lives. Is this ethically acceptable? Absolutely not. Furthermore, every day atrocities occur which not only undermine human rights, but also our conditions and our dignity. Torture centers, manuals with unprecedented techniques to inflict pain and death, selective murders, degrading acts which show the decadence of certain empires, such as what happened with the Imperial Roman Empire, or perhaps this is part of what some call the clash of civilizations, which the world is now facing. People who reveal these acts to the world, which are attacks and violations of human rights, are showing great responsibility to society, and they are of great value. As Julian's testimony shows, they are sacrificing their integrity and security as human beings. In July of 2013, the High Commissioner for Human Rights, Navi Pillay, called upon all countries to protect human rights from all of those who, or protect the rights of all of those who denounce abuses and illegal acts against human rights, and to ensure the respect to the right of privacy. As the High Commissioner rightly pointed out, there is no reason which could justify the violation of the right to privacy. The International Covenant of Civil and Political Rights says that no one should see their privacy, their family, their home, or their correspondence interfered with. Neither can anyone be pursued and much less tried for in absentia for publicizing grave violations of human rights. If someone is pursued for publicizing human rights violations, it is our responsibility to protect that person if they request. Any person who thinks their life is in danger has a right to protection, or at least that is what Ecuador thinks and Latin America thinks. More than 60,000 Colombian refugees were welcomed in Ecuador, which makes us the biggest receptor of refugees in the region, but recipient of refugees in the region. But it is not just an issue of numbers, because my country guarantees the rights of refugees, health, education, and fair work. In line with the principle of defense of life and the integrity of human beings, the Ecuadorian government gave asylum to Julian Assange. It must be pointed out that the reasons justifying the granting of asylum and the protection of Mr. Assange stand today. What took place in August 2012 and what continues today can only confirm the reality of the persecution and danger that Julian Assange would face if he were in a territory where the United States could easily capture him or request his extradition. We all know what happens to those who are considered enemies of the United States. All of us know, thanks to WikiLeaks and other sources, what is happening in the territory of Cuba, which is illegally occupied in the place known as the Guantanamo base. Also, Julian Assange has a very real fear of being handed over to the authorities of the United States by British authorities, the Swedish authorities, or the Australian authorities, in order to be tried for espionage and treason due to the revelation of compromising information on the United States government that we all know. In his request for asylum, Assange said that he was a victim of persecution, not just due to his ideas and actions, but also his work in publishing information which compromises the powerful, in publishing the truth, and also unmasked corruption and grave abuses of human rights against citizens throughout the world. In 2012, the government of Ecuador concluded that Mr. Assange could be extradited to the United States and he would not have a fair trial, and it is not a stretch to believe that he would be facing cruel and degrading treatment or face a life sentence which would not be respecting his fundamental rights. The exhaustive assessment of all of the circumstances surrounding Mr. Assange's case led us to believe that he met and continues to meet the requirements set up in the Geneva Convention on the Status of Refugees in 1951 and the Caracas Convention on Diplomatic Asylum in 1954, and we gave him asylum. Ecuador received information that said that at the same time when Soldier Manning was arrested, the Department of Justice in the United States and the FBI, along with other U.S. agencies, opened an investigation against Assange and WikiLeaks. In 2013, Soldier Manning was tried by a military tribunal for, among other charges, aid to the enemy, which means Assange and WikiLeaks, and was sentenced to 35 years in prison. During the trial, there were multiple references made to Mr. Assange and his possible trial under the espionage law. There are reasons that justify the belief that anyone who has been identified as a collaborator or cooperative with Chelsea Manning faces a high risk of criminal prosecution and political prosecution if they are in the United States and even outside of it. Another recent fact is that in December 2014, the international company Google notified its 3 associates in WikiLeaks that it had submitted to the U.S. government all of the content of their emails, their subscription information, and metadata. The crimes being investigated include espionage, conspiracy, and hacking. Mr. Assange's integrity continues to be at stake. But his personal situation in our embassy in London, where he has been for more than 1,000 days, also is a clear violation of human rights. He cannot go out to the sun in the only communal space within the building because there are always police forces present. Even though there has never been a criminal procedure against him, his passport was revoked in the UK. This was until just a few days, after more than 4 years, continued until the Swedish prosecutor decided to take his testimony in London. The harassment of members of WikiLeaks, the Manning trial, the paralyzation of the trial in Sweden for years without any justification, which the British authorities used to justify keeping Assange there, his confinement, his harassment in our embassy are signs of the grave risk that he faces. A military judge, Dennis Lind, ruled that Manning had been the victim of mistreatment during her custody, since she spent 9 months in a cell without windows, where there was no natural light and could not carry out exercise. These conditions were considered cruel, inhuman, and degrading treatment by the Special Rapporteur of the UN. Assange has been 34 months without light and without the possibility of exercising. The UK has in its hand the decision to the possibility of ending this confinement and recognizing the full validity of the Geneva Convention and the Caracas Convention, as well as all of the international instruments. And allowing him safe passage to Ecuador. The UK would be taking a decision, if it did so, which is recognized and protected by the Universal Framework for the Protection of Human Rights and EU law. This means that the life and integrity of Assange depends on a political decision. And finally, I would like to point out that we are very interested, and we very much would like to take Mr. Zayas up on his suggestion, namely for the Human Rights Committee to carry out an investigation on how to protect whistleblowers and perhaps a special rapporteur on the protection of privacy in the digital age. I would like to thank all of the participants, Mr. Zayas, Judge Garzon, Eva Joly, and particularly our colleague, Nicole Savia, for having shown the initiative to support our mission here in Geneva in the organization of this event. Thank you very much for your patience. Thank you for being here until the end of the event. Thank you. Thank you very much, Ambassador, for your presentation as well as all of your support. As was said before, freedom of the press has always been very important to Ecuador. We have 5 minutes and not that much longer for comments and questions. If someone would like to take the floor, we will do the best we can given the time constraints. The Ambassador of Cuba, you have the floor. Just very briefly.
The title of the side event was very suggestive one, and after hear all the speakers, I will continue in Spanish on that. But having in mind that the title is in English, and I would like to answer from my personal opinion after having heard all the speakers. Western persecution, yes. Is the Human Rights Council equipped to protect refugees from the West? Probably we have the tools, but until we have these double standards to approach these very important human rights issues, we are not going to be prepared in order to face this kind of issues and situations. Continues in Spanish, continuando en español.
And to continue in Spanish, I would like to highlight this particular idea. I think that it's very important to point out these issues and to hear the different perspectives. And I would like to emphasize this issue of a double standard that many countries use, unfortunately, when they are dealing with these issues. They call upon countries from the South to improve their human rights situation, to improve the respect for expression and opinions, but then they submit citizens such as like Julian Assange and Edward Snowden to a vicious manhunt for their revelations in WikiLeaks, and also applying the Espionage Act, which is the violation of their own sovereignty as well as the sovereignty of many other countries. And so we would like to say that we approve the universal approach in applying the human rights of everyone, and they need to be respected by everyone, and no pretext can be used, such as national security or the fight against terrorism, to violate them. Obviously, the international community backs the fight against terrorism, but that cannot be politically instrumentalized in order to create these dishonorable acts and to limit the freedom of expression and assembly and political opinion, which we have in all countries, and also these citizens who expose the truth of those who are responsible for war, the killing of many civilians, the use of deadly technologies, kidnappings and denial of justice to those who are facing arbitrary detention, as well as torture, which has been mentioned, takes place in the naval base of Guantanamo, which is a part of Cuba which is occupied. So we hope that this conversation continues, and we hope that this arrives to the Human Rights Council and invite the member states to talk about this issue with the utmost clarity and to shed light on these facts so that they can be known, because there is a smokescreen in place, and until these acts and facts are discussed transparently and openly in the Human Rights Council, we will continue this discussion without real benefits in the protection and promotion of human rights for all. Thank you.
Muchísimas gracias, agradecemos su participación y gracias también para denunciar una vez más el doble rasero que tanto está discreditando la labor de este Consejo, así como más en general el sistema de Naciones Unidas.
Which discredits the Council. I now give the floor to Venezuela. Thank you, Nicole. Good afternoon. First of all, I'd like to thank the Permanent Mission of Ecuador for organizing this important side event. And I'd also like to thank all of the panelists who have spoken. For us, for the state of Venezuela, as the ambassador of Cuba has said, we are all concerned at this issue of international spying, espionage, improperly used by Western powers with the excuse of the fight on terrorism in order to undermine the sovereignty of states. Venezuela, with other countries, have denounced this on different occasions in different fora. The case of Julian Assange and with Snowden. Our government has taken a clear stand that this is totally out of line. This is a very clear violation of all international standards in human rights. The flagrant violation of the right to justice, that somebody should be under threat in an embassy for more than 1,000 days, is totally out of line with international law. And so we too would join our voice to that of Ecuador and those of the panelists, so that in all fora, especially in human rights fora, we should speak out against this type of activity, and that those who are responsible, or the countries that can call to order countries that are doing this internationally, do so as soon as possible. Thank you.
Muchísimas gracias por la intervención. Pero ya no tenemos tiempo porque son las 5:05.
I'm afraid we have no more time. It's 5:05. I just wanted to know if Eva Joly wanted to conclude. Another couple of questions.
Thank you. My question is a follow-up to the statement made by Cuba about double standards. How is the international community ready to face the defective articles within the charters of the United Nations and the sub-organizations that pave the way for the Western countries to exploit international law and conduct crimes against humanity, in another term? How are we ready to face these articles in an effective manner? Thank you.
Yes, I can try to answer. I think what we are watching is really a change of paradigm in the relations between the state and the citizens. Democracy is based on the fact that the citizens are controlling the executive. And what we see here is that the secret services are out of control, and that the democratic control do not function anymore. So it is time for us to use all the tools in the toolbox, and the UN Convention on Human Rights is one of them. We are not used to use them on Western refugees, but what we see here is that the pressure is tremendous, and that when Snowden tells the whole world that we, the member of European Parliament, we are being spied on, that Angela Merkel is being spied on, nothing really happens. And so I think we have problems understanding what is going on. We do not understand what this mass surveillance means. It has nothing to do with security. What we know also is that a lot of this spying is for business, is also to intervene in the treaty negotiations between the US and Europe. It is to have better arms. So I think we are in a situation where we have to defend our democracy, and we must use absolutely all the weapons that we have got, the democratic ones. I think we are in danger.
The closing remark for Mr. Zayas, and it's finished.
Yeah, quickly, as a closing remark, let me reiterate the proposal that the Human Rights Council task its advisory committee to carry out a study on the human rights facets of the persecution of human rights defenders, including whistleblowers, and to formulate mechanisms to effectively protect them. I recall that the UN Charter and the human rights treaties make up the Constitution of the world. Articles 1, 2, 55, and 56 of the Charter obligate all member states to respect the sovereignty of states, prohibit interference in the domestic affairs of states, and commit all states to promote and protect human rights. Article 103 of the Charter stipulates that if there is a conflict between the UN Charter and any other treaty or agreement, it is the UN Charter that prevails. Therefore, the rights of whistleblowers must be ensured, and victims of violations must be rehabilitated and must be given adequate reparation. Thank you.
Solamente dar las gracias a todos.
I wanted to thank all of those who have been here today with us, and throughout this afternoon's session, perhaps there has not been a mention of something that we should have started the session with, and that's Article 19 of the Universal Declaration of Human Rights, the right to freedom of expression. And I think that everything that we have said this afternoon is there. And I agree with Eva Joly that the risk of this massive attack on the basis of national security and the rules governing national security vis-à-vis society can be seen, and we need to be able to protect those who are normally the vehicle for denouncing all of these facts. For this reason, and as a lawyer and member of Julian Assange's defense team, I would request this support so that these principles truly be respected and we put an end to persecution that in this case Julian Assange, WikiLeaks and others are being subjected to in the exercise of their profession and the exercise of the freedom of expression. Thank you. Thank you, Baltasar. Thank you. Time has defeated us, but not inaction. I think I detect significant urgency to continue to discuss this within the Human Rights Council. It is the appropriate body, and once again, I would mention how important it would be to have a spokesman, special representative for defense of privacy, and that we submit to or ask that a report be requested from the Advisory Consultative Committee of the Human Rights Council to protect whistleblowers. If we don't do this, we will be weakening the legitimacy of the whole multilateral system of the United Nations and of this Human Rights Council. Once again, thank you all for being here. Thank you for your support and for keeping with us during this crusade. Thank you.